You see the whole court packed with people. You know, some people were there from morning until night, waiting for the case to come on. It's bad case management.
There's no reason why a judge should spend his time writing longhand. And one of the essential aspects of a criminal trial is the ability of a judge to observe the demeanor of the witness that appears before him. If you have your head buried, taking notes constantly, then you're not observing the demeanor of the witness. And it's an essential part of my case. And you know, it's extremely frustrating when you have just so slow down, I'm writing, and his head or her head is buried throughout. Observe the demeanor of the witness, but you can't blame them. The system is not in place.
So it's the chief judges who should...
Chief judges, in some states, maybe the Attorney General can provide the enabling environment, as they say, you know, more facilities in court and all that. Maybe that may help as well. But I think, I don't know how the budget system works within the administration of justice system, but I would believe that a combination of both, just to provide the enabling environment and what judges need to do their work. Why does a judge need to adjourn the proceedings for a week to make a ruling on a bail application? It's a standard application in criminal proceedings. You hear it every day. The principles are well set, they're well established. You're either going to grant bail or you're not going to grant bail.
The offense is ordinarily bailable or it's not.
It's either bailable or it's not. What do you need a week to decide whether you're going to grant bail and the conditions that you're going to impose thereon? You don't need a week for that. You retire into your chambers and you come out 2 hours later and you give your ruling. And it's done.
And some judges even write their rulings on the spot.
It's routine. It's a routine application. And I don't understand it. I'm going to adjourn for 3 days to make a ruling on a bail application. What's so complicated about a bail application? You know, so I mean, that's all part of what we talk about case management issues. There's so much time is spent on unnecessary stuff.
I think there are some judges who do that. I mean, I've been in front of Justice Buba, who I've seen give immediate rulings.
We had it too in the case I was in Abuja, but so there was very high profile, and you know, so.
But a lot more judges.
A lot more judges will take a lot of time to make a ruling on a bail application, and I'm like, well, that's not really necessary. It's not fair. It's absolutely unfair.
You've alluded to the regulation of the legal profession, so let's talk about that. You're a member of the British Nigeria Law Forum. What recommendations, if any, have you made to the committee set up by the president of the NBA?
When the president of the NBA was running, I sent him a message saying that I was very interested, because one of the areas that he was very interested in is regulation of the legal profession. And I said to him that it was one of the areas that I was interested in because of my background with the Bar Standards Board in London, which is the regulatory body, because I sit on the Bar Standards Board, on the qualifications committee of the Bar Standards Board. So it was an area that I was very interested in. Unfortunately, I wasn't put on the committee. But as I said, I'm a member of an organisation called British Nigerian Law Forum. So we got the terms of reference of the committee, and we went through each and every terms of reference. I mean, we submitted a 40-page document. I mean, it took us quite a long time and effort. But the reason we did it is because we're very interested in improving the standards here. We were then sent a number of questions in relation to various aspects, and we answered that with another 20. So all in all, about 60 pages. But for me to go through every single one now would be very difficult in a short space of time. But the effect of what we were saying is that Nigeria needs to move away, the legal profession in Nigeria needs to move away from self-regulation. We cannot regulate ourselves. Now, our position was this, that we should set up a body, a regulatory body, made up, the majority of the members should be lay people.
Non-lawyers.
Non-lawyers.
Absolutely, yes.
The majority. So say, for example, you have 20 on the body. 10 should be lay people, 9 should be lawyers. So the lay people are always in the majority. That's proper moving away from self-regulation. Now, the reality is I don't think that Nigeria is ready for complete non-self-regulation. I don't think Nigeria is ready.
But why are you proposing that we move away from self-regulation?
Well, we are, because we don't think that we are capable of regulating ourselves, because there's no objectivity. You know, there's this tendency in the profession to look after your own.
Absolutely.
That's a factor, that's a feature of moving away from self-regulation, so that effectively, because at the end of the day, us as lawyers, it's the public interest that's important. You know, are we doing things right for the public? To protect the public. Are we doing things right? And I think history has shown, because after all, in the UK, it used to be self-regulated. You had the General Council of the Bar who regulated the profession. But in 2006, it was felt, well, before that, but the division of the regulatory side of the profession came in 2006. I mean, in fact, it was actually the government that forced the position. Yeah. They forced the position. They said, listen, you can't continue to regulate yourselves. So it's not only, it doesn't only apply to lawyers, it applies right across the board. So you have doctors. They have a separate regulatory body that deals with regulation. Nursing and midwifery, nurses and midwives, the same thing. You know, so it's important that we get to a position where we're no longer self-regulated. I think that it's likely that we will have a halfway house, but not complete moving away from self-regulation.
I don't think enough has been done in Nigeria to protect the unsuspecting public, and I think that's really where this issue arises. I mean, like he rightly said, you leave law school today, you set up a law firm tomorrow, and the general public is at risk of all sorts of things: bad legal advice, bad legal representation, substandard service, and there has to be a greater drive towards protecting members of the public